and so on. But it's not a clean deal. Okay, double jeopardy. But the reason it's in there is because it was being done all the time. It was being done all the time by the king. No compelled self-incriminate, the right to remain silent. And then in the Sixth Amendment, you got your right to a defense attorney. So let's talk about Miranda to a counsel, right to an attorney. Miranda laws, starting back in '64, I believe, when Mr. Miranda in Arizona got put in jail for something and spilled his guts. He had a good attorney who said, look, some of these rights are so basic that really the government ought to tell people that they have the right to remain silent and they have a right to an attorney before they, and if they don't do that, then it ought to be fruit of the poison tree. It ought to be inadmissible under the exclusionary rule. And so the Supreme Court agreed to that. And so now every single state, of course, as you know, we all watch Law and Order or whatever movies you watch, they get arrested, they always read you your rights first. And all 50 states have Miranda rights. They vary from state to state, but all of them include two things. You have the right to remain silent, Fifth Amendment, and you have the right to an attorney. And some of them include some other things, but they all include those two things, right to remain silent and right to an attorney, Miranda rights. Due process of law. In the Fifth Amendment it says, I just want to bring up another case, when we got these first 10 amendments, this whole thing that they were worried about was limiting this new national government. They didn't want it to get out of hand. We just got away from a tyrannical government. And so the first 10 amendments only applied to the national government. They did not apply to the states. Now the states, all of them, already had a Bill of Rights or a Declaration of Rights, they called them, but they weren't all the same. And so if there was not something there about freedom of religion or establishment of religion, and as a matter of fact, some of the states did have a state religion. The state religion in Massachusetts was
Catholic.
No, it was the Church of England, Puritans.
Quakers.
Huh?
Quakers.
Quakers. Was it the Quakers? Or was it Roger Williams left there then and started Rhode Island, I think, Rhode Island Plantation, so that they could, to get away from the religious persecution that there was in Massachusetts. Remember, you had the Salem witch trials. It was religious persecution. I'm digressing here. Why was I talking about... the due process. So these things, you could still be tortured in a state if they didn't have that in their Declaration of Rights. It wasn't until we got the 14th Amendment in 1868, and they then used the 14th Amendment, equal protection section in there, saying, and they then applied every single thing that's in the Bill of Rights to the states also. So you and I have grown up with the idea that neither the states nor the national government can violate any of these 25 basic rights that we have, but it wasn't always that way. So in the Fifth Amendment, we have this due process. It says the government, meaning the national government, cannot take away our life, liberty, or property. You can't charge us and find us guilty of a crime without due process of law. Well, what's due process of law? Of these 25 rights that I count, unalienable rights, I count about 14 or 15 of those are criminal due process rights, such as the right to remain silent, no double jeopardy, right to, in the Sixth Amendment here, right to a speedy trial, right to a public trial, right to an impartial jury trial. Also in Article 3, Section 2, that's where it says all criminal trials, we have a right to a jury trial. That was such a basic thing. The right to a jury in Old England, the English, the Christian Commonwealths there, the idea was that the jury represented the sovereigns, the people. They were the highest form there. It was above the government. So you had the right to a trial by the people, not by the government. The judges were just there to be referees. And so the jury was a sacred right. And we wanted to make sure we had speedy trial, public trial, impartial trial, notice of accusation. We have the right to be told what we're being charged with. It hasn't always been that way in human history. It wasn't that way whenever the government didn't want to do it. And they had a Spanish Inquisition or a Star Chamber or whatever some of these courts were. And people were put in jail without being charged with it. So we have the right to being... Ramos and Campion, they had them in there for 2 or 3 years, and the attorneys were saying they have the right under the Constitution to be told what they're being charged with. And the government said no. The Military Commissions Act takes away all their constitutional rights. By the way, that's another point. Our founding, a lot of people will say, well, if they're not American citizens, they don't don't have the right to, they don't have any constitutional rights. That is not true. Our founding fathers were very clear about that. These are God-given rights. These are unalienable rights. They're given to people. They are inherent rights. We have them by our very humanity. These are all rights that the government doesn't give to us. They can't take away from us. And we have and so when we say that we have all these rights, or if it's an illegal alien in here and they're charged with a crime, they still have the right to an attorney, and they have the right to remain silent. They have the right to not be tortured, because all of these are God-given inherent rights that the government didn't give to us, and we the people have listed them. Yeah.
Tom, they need to define the word torture. We've made a big issue out of waterboarding.
We're going to get to that, yeah. Let's go right to torture then. Go ahead.
Waterboarding does not break the skin, does not draw blood, doesn't break bones, doesn't even leave a bruise. It scares the crap out of you. And
it scares the crap out of you. Out of 100 actually drowns. Big deal. But you're right that it's something upon which reasonable people differ, and so our government uses it. And
a lot of our military men today are going through that in their training. I went through that kind of training several times. I didn't get waterboarded, but two guys grabbed me by the waist, turned me upside down, and stuck me head first in a barrel of water. Mm-hmm. And they pretty well had.
It's tough upside down.
Yeah, I was a diver, so it.
Well.
I outlasted it. But that waterboarding goes on every day.
Okay, I've learned in my classes, and my job in school is not to resolve these kinds of issues, but to say the Constitution says no cruel and unusual punishment, and we usually say no torture. But so the question is, does waterboarding constitute cruel and unusual punishment? And that's still being argued about. Some people feel very strongly one way and the other way. Another one is rendition. Rendition is, now you're ex-military, so you might be familiar, but rendition is the process by which, our Constitution says you can't torture prisoners of war. We believe that's and so we have a process that we call rendition, where we turn them over to our allies in Germany or Turkey, for example, who do not have such little niceties as the Eighth Amendment there, and they can render the truth out of them. I think of rendering factories where you render the fat out of pigs. Wow. Or something. They're going to render the truth out of them in whatever way that they do that, and maybe not break their skin and so on, and then send it back to us, and then we can say, we didn't do it, we didn't torture them. That offends my sense of justice. I think of master-servant law. And if I hire someone a hitman to kill my brother-in-law, and he does it, I can't say, well, I didn't do it. He did it. But that's what we do with rendition. We do allow someone else to use some cruel and unusual methods that we are not allowed by law to use here in America to render the truth out, and we call that rendition. And so that's another issue. But where do you draw the line on that? Exactly what are they doing? And I don't know. Are they hooking? I don't know. But those are two, waterboarding and rendition are two of the major issues that we have in the world today on the Eighth Amendment. Right to trial by jury, can confront our witnesses. A star trial, the old star chamber, or the Spanish Inquisition. You're charged with something, and we have information you did such and such, it's sedition, it's heresy, and so on. Who said that? I'd like to cross-examine them. I want my attorney to cross-examine them on a well, they didn't get to do that, but in America you get to do that. We have the right to confront our accusers and to try to undermine impeach their credibility and show that they were lying and so on. Right to compulsory process for so-and-so can tell that he was in the bar. I was in the bar that night. I didn't murder him. I was somewhere else, and someone could, and that person doesn't want to come. You have the right to compulsory. The government can force that person to come and testify in court. Now, they can't get him to maybe say exactly what you want them to say, but at least they have to come in court and testify under oath what they know. Right to a defense counsel, right to notice, right to basically, it says anything over $20, and that's still technically to a jury trial in civil. Before this, an article of jury trial in